for your closing session. You may be seated.
Your Honor, I am not going to move admission of what I've given you as H, I, and J. The state has agreed to a stipulation that they've been provided documentation to indicate that Owen Labrie is enrolled in an educational program in the Boston area.
Okay.
Correct?
Yes, that's correct, Your Honor.
Thank you. On January 28th, there was a morning violation that morning. He left early to go to Boston. He left early to go to Boston for a lecture that day. And Exhibit K, which I do move as a full exhibit, is a text message between Owen and his mother that day, indicating that he was in school that day, and Owen referring to the lecture being really good that day. The next exhibit, Exhibit L, is documentation between Owen and a professor. We've agreed to redact the name of the professor on Exhibit L. So the two-line, I'll redact at the end of the hearing to redact that. That's correspondence between Owen and one of his professors, indicating that he does go to Boston to meet with professors on occasion as well during their scheduled office hours. And those scheduled office hours are rarely within the 2-hour window where it could be permitted for him to travel within curfew. I'm not going to move admission of Exhibits M and N. I am going to move for admission of Exhibit O, which is again text message correspondence between Owen and his mother regarding his travel to Boston on February 29th. His travel to Boston on February 29th was contrary to what he told the reporter on the bus, or the woman who accosted him on the bus. He told the person that accosted him that he was meeting his girlfriend for the same reason that I've told you, Your Honor, which is he is not so silly as to try to keep what he is doing from reaching the public eye and then tell her, oh, I was attending classes at XYZ university or college, and then have her do exactly what she did, which was tweet about her encounter with Owen Labrie. He did tell her that day he was meeting with his girlfriend, but in fact, he was not. He went to class, and this is a text message between him and his mom asking about class. On that same day, which is Exhibit P, and we have some agreed upon redactions to Exhibit P, which I can also do at the end of the hearing. But on that day, Owen Labrie also went to a library where he obtained a library card that same day and conducted research in that library, and this is documentation from the library that he was in fact in the library on that day. My last exhibit, Exhibit Q, is my correspondence with Attorney Ruffle that I had alluded to earlier, whereby I had asked for some leniency for Mr. Labrie's curfew, and the response that they needed specific information about where he was and what he was going to be doing, as well as the state's suggestion that he participate with online courses, which is essentially what he's doing. But even online courses do require that he travel for research, that he travel to meet with professors, and that on occasion he traveled for lectures. And that is why, on 3 occasions, Mr. Labrie traveled to Boston earlier in the morning. The state is included on this sheet the February 17th and February 18th travel, but they seem to be conceding that they're not counting those currently because Mr. Labrie had communicated with Merrimack County Pretrial Services prior to those travel days. He was meeting with legal counsel. They knew that, they had given him permission, and he traveled on those days for those meetings with legal counsel with the knowledge and the permission being granted by Merrimack County Pretrial Services. I understand the state's argument that Merrimack County Pretrial Services did not have authority to do that. We certainly thought they did. They were supervising him. They were supervising his curfew. Counsel, previous counsel, Attorney Carney's office, had contacted them about travel to their office for a meeting outside of curfew hours. And both Owen and myself were under the impression that if they had granted him permission to travel, that it would not be a violation of his bail conditions. You'll note in Exhibit C, the Merrimack County Pretrial Service notes, for other individuals, they do note at times granting permission for, I got caught up, I lost track of time, and there's notations in there from the agency when that occurs. I suppose if there's no mechanism for that, then Mr. Labrie is really in a jam because there's nobody for him to contact. If he's in Boston and misses his bus, who does he call? I can't get to the court and file a motion if he misses a bus in Boston and is going to miss his curfew. He needs someone to call. So what I have suggested to the court is that a minor modification to this bail order, just allowing pretrial services to grant the permission, would alleviate this whole problem. Then it doesn't have to be public. The media doesn't have to know. Nobody needs to know when Mr. Labrie is going to be at a bus stop, where he's going to be, when he's going to be by himself at 5 a.m. getting on a bus, and accost him in the bus station. We won't need to worry about those things because the notification will go to the Merrimack County Pretrial Services. They would know where he was at all times. Mr. Labrie has never failed to call in. Every night, whether it's late or not, he calls in. The only missed calls he has are the dates when I filed the motion with Your Honor to ask that he go to Michigan to see his ailing grandfather. And the only reason we filed that motion, instead of going through pretrial services, well, there's two reasons. Because Merrimack County Pretrial Services did not think they had authority to give overnight permission. But because the state agreed, because I reached out to the state and I said, here's the details, here's the letter from the doctor, and here's grandfather's name, and here's the address, and here's all this information, will you assent? They said yes, which enabled us to file a motion that was fairly generic with Your Honor, asking for the permission, so that people wouldn't call his grandfather's house, so people wouldn't call his grandfather's doctor, so that media wouldn't show up outside his ailing grandfather's home. And if we had had to do that, if the state had not assented to that and had said to us instead, file a motion where we would have had to put in all those details, Owen would not have seen his grandfather then, because he was not going to subject his loved ones to the kind of scrutiny that he has to live under. So we ask Your Honor's forgiveness for the few violations, the understanding of why it occurred, and a minor modification which would prevent this in the future.
Anything further from the state?
Your Honor. I would like to point out that indeed the state would not agree when asked generically without more information. There's a public safety issue here. The defendant is a convicted sex offender requesting at the time, and this was much earlier, an amendment to his bail order which was entirely vague and without basis. The state would not agree in a situation where there has been no rehabilitation, there's been no evaluation, there's been no sex offender treatment. The issues that he had were on a school campus. The state was not going to put the public in a situation where he would be on another campus without any supervision. That being said, there's absolutely no reason why counsel couldn't file a motion under seal, a redacted motion. The state did not have to assent to a motion in order for them to seek the remedy that they needed from the court. I would also like to point out that the documentation that's been provided from Attorney Carney's office does not indicate a time that they were meeting. It does not indicate that they advised him to breach his curfew in order to meet with them. It would be my understanding that there would be billing records that might possibly have those times available. They haven't been provided to the court. And I would also like to indicate that there was very specific conversation between the state and Attorney Carney's office when the defendant was making arrangements to meet with probation officer Norm Marquis for the PSI, that they were very cognizant about notifying the state that on that occasion it would indeed be necessary for the defendant to extend his curfew. There were no other conversations with the state about any other meetings that were necessary or that would be necessary for him to breach his curfew. I find that particularly interesting. I also would like to note that the information that you've been provided, Your Honor, indicate that the defendant is enrolled in an online educational program, and that the event that occurred on February 29th, it's January 28th, is a webcast. There is absolutely no evidence in this documentation that shows anywhere that it was necessary for the defendant to travel to Boston in order to pursue this education. And I would argue that this is not about his noble quest for education. As I indicated in my offer of proof, there are two people that the defendant indicated that he was going to Boston on the February 29th visit to visit his girlfriend. One was the ticket salesperson that sold him the ticket that morning, and the second one was the reporter on the train. Again, I would also like to point out that he's willingly given a very broad interview to Newsweek magazine that's been published nationally with photographs inside both his mother's house and his father's house. If he's concerned about his privacy, why is he speaking so openly to Newsweek magazine? And going back to my previous point, Your Honor, in regard to visiting his girlfriend, I indicated earlier that the state had information in regard to this incident on the 19th of December 2015, which a ticket was purchased.
Your Honor, I object. May we approach?
Yes.
The state inquired into the details of that, and what we learned was that when a ticket is issued, the traveler's identification, the traveler's name is put on the ticket, and this ticket was issued with the defendant's name, which it actually should not have been. That was an error. He was purchasing the ticket for his girlfriend. We also learned that among this information, you can see that some tickets were purchased with cash. Others were purchased with a credit card, and these numbers are the last four numbers of the credit card. And there were two different credit cards that were used, and again, we were able to have access to the personal information whose account that was, so we were able to identify that this defendant had actually used those credit cards to purchase tickets. The bus company was able to do a search on each of those credit card numbers, and we were able to determine that the defendant had purchased tickets for his girlfriend on multiple occasions over an extended period of time. We were able to identify her, and we were able to confirm that she is a student at Harvard. And I point that out, Your Honor, just to minimize what they are arguing, that these are purely educational purposes for his traveling, when indeed he was traveling to socialize as well.
Anything further?
The only other point that I want to make, Your Honor, is the point that I reiterated earlier. The defendant is not on pretrial services supervision. They were not supervising his curfew. They were monitoring the caller ID to make sure that he was at his mother's phone number in the evening as he was supposed to be. They do not have the capability of monitoring the curfew of an individual that lives out of county.
Go ahead, Ms. Rancourt.
The issue of whether or not he was meeting with his girlfriend when he was in Harvard is mere conjecture on this part of the state. The documentation has shown that, in fact, he was meeting with professors and or attending a live, what was also a webcast, but was also a live performance. And why would he be texting his mother about attending a lecture if he was not attending a lecture? The texts speak for themselves. They're made contemporaneously. They're made on October 28th, on January 28th, prior to being notified he'd be in court. So the documentation speaks for itself that he's there for educational purposes, as well as the date he was in the library, and the library documents that he's in the library, not with his girlfriend, contrary to what was tweeted by this individual who accosted him on the train. The individual that accosted him on the train got a lot wrong in those tweets, quite frankly. She said Mr. Labrie lived in New Hampshire, where he lives with his parents in New Hampshire, and we know he doesn't live in New Hampshire. She made comments about the evidence at trial that was incorrect in those tweets. So I don't think we should rely on statements that are clearly unreliable made in those tweets.
Your Honor, I just wanted to add just a couple points because I just misspoke, and I want to clarify that for the record. When I said that pretrial services is not capable of monitoring the curfew for an individual living out of county, that was accurate when we sentenced the defendant in October. Under the direction of the previous pretrial services director, it was his policy that he did not wish to, and there was not capability at that time to do so. However, under our new acting director, Jim Mull, and with the advance of cell tower service, there are companies now available that would be able to monitor an individual on an ankle bracelet, electronic monitoring. We do have the capability now that we did not have at the time. So when I just spoke, that was not entirely accurate. They could do that at this time. It would be a cost to the defendant. But the other point that I want to make, Your Honor, is that this is all off track. We wouldn't be here if the defendant had filed a motion with the court to amend his bail as he is required to do. There's absolutely no justification or excuse for them stepping outside of the law and taking the rules into their own hands. And I thank you, Your Honor.
There's nothing further. I'm going to take recess, review the exhibits, and then I'll be...
Thank you, Your Honor.
All rise, please. Court's in recess. You may be seated.
Huh?